About 4 or 5 years ago, as an adjunct to my work that I was doing in corporate governance, and I was also dealing, of course, with entrepreneurs who were struggling with the financial problems and trying to reorganize them and engage in corporate renewal exercises. Invariably, they would have a lot of credit card debt. When other sources of income became closed to them, they would charge up a lot of materials on their credit card and so forth. And the rates on these things, of course, 20, 30, 40, I've seen 50%, and that's not including the penalties and late charges and so forth. Something struck me as wrong about that, and why is that the case? And as you research the area, I did this in my spare time, and couldn't figure out how this could possibly be. National banks clearly are allowed to charge the highest rate allowed by the state in which they're located. And of course, there's a famous case that says that located means the state in which you're chartered, not the state in which you're doing business. So that allows any state to export its usury rate. And of course, the governor and the Walter Wriston, the then president, chairman of the board of Citicorp, made an arrangement where South Dakota would repeal their usury laws, so there'd be no limit, and they could therefore charge unlimited rates. That happened in 1982, and there was something. Why is this permitted? It seems like an incredible Faustian bargain, and that, of course, gave rise to the unlimited credit card rates. And something struck me as there's got to be something wrong in this, particularly since the next sentence of the federal usury statute says that if no rate is fixed by a state, then banks are limited to 7%. And the story of that and how I researched that and found what I like to refer to as a type of smoking gun in the legislative history, which was buried in the Congressional Globe, which is unindexed, is another story and probably too long for today. The case that was in Lawyers Weekly recently was the case of Citibank versus DeCristoforo, a woman who had charged a lot of things on her credit card when her husband's business was failing. She ran into financial hard times, as did he. His business eventually failed, and eventually this suit was brought. There were two credit cards at issue. I think they were. I think one was about $26,000, and the other one somewhere around $10,000 or so. Obviously, I have limitations about what I can speak about on pending cases. Obviously, the nature of the credit card industry, the nature of the too big to fail banks that have the ability to engage in what I think is perceived as a type of moral hazard because of their having no downside. They will be bailed out of their problems and their mistakes in the way that common citizens are not bailed out. Much like Einstein points out that when you're dealing with objects of great mass, of huge mass, like the sun or planets or black holes, they actually bend the fabric of space around them. When you have banks or institutions that reach too large of a size, they actually bend the fabric of the law around them. And so rules that do not and should not apply to the majority of people become warped and applied in these situations for our own preservation. That raises much larger issues that are, of course, not of a purely legal nature, in terms of whether there should be limits on the size of banks, whether there should be higher capitalization rates the larger you get, so that they will be obligated to divest themselves of assets and become smaller so that they are not too large to fail. And there's a lot of literature written about that. I think that the vast majority of the citizens in this country, my guess is, feel that there's something wrong with the magnitude of charges that banks are permitted to lay upon them and their ability to change them willy-nilly and apparently without reason. Of course, the banks will disagree. They say it's their contractual right to do so, and in a sense, they're right. But at what point does contract become improper? There was an infamous court in the 1900s called the Lochner Court, where that was a very activist court, which viewed the 14th Amendment as protecting freedom of contract. The problem with that is that if you have an asymmetry in bargaining power, you have the ability to dictate price. And so the promise of equal protection is rendered illusory by the fact that the status quo has created a system where freedom of contract is not meaningful. In 1905 and throughout the early 1900s, very late 1800s, the Lochner Court said it was unconstitutional, therefore, to have minimum wage laws because, you know, you're giving a subsidy to the poor. If Congress wants to give a subsidy, let it give a subsidy, but this is violating freedom of contract. We, of course, view that as foolishness today, and realizing that, of course, that was an era of social Darwinism and so forth. So if you just say, well, it's our contractual right, that doesn't really answer the question. And what the judge in the case that was reported said was that these are contracts of adhesion, and when you have a contract of adhesion, the court is obligated to look at a contract where there's not a meaningful opportunity to bargain to see if it's fair and reasonable. And clearly, this is a situation, at least viewed as this judge, as something that is unconscionable. The usury laws themselves are a congressional decree of unconscionability, but judges also have the ability to determine that in particular instances contracts are unconscionable. It's my hope that in the final analysis, rather than having to look at each case on each contract on a case-by-case basis, and as interest rates rise, whether they're now no longer unconscionable, that the fundamental basis that was established by Congress back in 1864 of the 7% limit will, in such instances, will be sustained. But again, that's not for me to decide. It's for the courts, and I'm just a lawyer here. But this is a test case which I'm pursuing. There's a couple of others that where court didn't agree with me in the district court, and will eventually have to be decided by I'm hoping our Supreme Judicial Court, and depending upon what happens in that case, perhaps an appeal to perhaps the Supreme Court will take certiorari of it. If my position ultimately is sustained. Well, first of all, even at the 18% level, it will have a devastating effect on the banks, restraining them from what they are doing currently, what they've done in the past. The statute allows for recovery of the last 2 years' interest payments, to the extent, of course, they have an offset for principal, but it also says that you cannot they have no right to collect interest if they violated it, so therefore all payments go to principal. There's no interest charged over the life of the credit card, and you can get your last 2 years back. There's an enormous amount of damages that would be recoverable in those instances. Obviously, it gets even larger if the number is the 7% limit that I have argued. Total damages. The figures I've seen is that the credit card industry involves interest charges of approximately $225 billion per year. You're obviously looking at 2 years, plus restraints for future years until Congress changes the limit. And so obviously you're dealing with another financial crisis if that sort of damage should be imposed. I will say that that something needs to be done, in my view. I think the statute does cover it, but that's what happens when you rely on your pure contractual rights, and courts determine that there's been an abuse, or Congress determines that there's been an abuse.